Hello there, I'm Tate with My Court Coach, and I have by my side once again the attorney, Chris Fontala. How are you doing, Chris?
Good. Good evening, Tate.
I'm glad to have you here, as always. And I want to, let's put up a banner here, letting people know that anything they hear today on this live stream is not legal advice, and they should not take it as legal advice. Anything you hear, you should take as just information from two lawyers who are talking about their experiences and what they've seen in family court. We're not your lawyers. We are not establishing an attorney-client relationship with you at this time. Remember that everything on this live stream is public, and so you're not going to want to divulge children's names, things like that. Now, what is My Court Coach? We're here because My Court Coach is a resource for people who need help in court. We have a course on California family law with lots of helpful downloads that you can get that you cannot get here on YouTube, but you can get at the website at mycourtcoach.com. In addition, we have resources that will help anyone in any state, in any court, for any case. If you are going to be presenting your case in front of a judge, we have things that can help you. Go to mycourtcoach.com and look for the full court preps, and you'll get everything you need right there. Today, we're going to be answering some questions that were posted on comments to videos that we have, and that's why Chris is here to help us with that. So are we ready to get started with that?
Sure.
All right, let's do it. Let me see if I can get the first one up here. Okay. So we received a comment on our video. It's over and done. Judgment of summary dissolution in California Family Court, Form FL 825. And the comment says, "Hi, attorney. I have the FL 180 dissolution judgment. Does that mean I'm still not over with the divorce?"
Usually that means you're done with the divorce. Now, it's possible that it's only a partial judgment, and on that FL 180 packet, there are specific reservations of things that still need to be resolved. But assuming that's not the case, you are, quote, done with the divorce. Now, the court does retain jurisdiction to modify orders for custody and visitation of minor children, and it does retain jurisdiction to modify support. And that will go on, until it terminates its jurisdiction to modify support. With child support, usually when the child is 18 out of high school or 19 at the latest, and with spousal support, it's usually spelled out in some way. And if not, you may have to file a motion to terminate support somewhere down the line.
So what about after judgment? What about notice of entry of judgment? Is that different or the same thing? Or
usually the notice of entry of judgment comes at the same time.
Okay.
But I'm not exactly sure what he's asking, but I guess I'd have to look at it. But, he could always take it to the facilitator's office in his county and ask him if there's anything left to be done on the case, too. And usually they will look that up and say, nope, you're done. Or, no, that's not correct. The judge specifically ordered you to deal with whatever is left to be dealt with.
Okay. All right, perfect. Good. Anything else on that?
Nope.
I don't think so either. All right, let's take a look at the next one. There's a question. We have a question here in our video, which is entitled "Waiver of Hearing on Denied Request for TRO, Temporary Restraining Order, California Family Court Form DV-112." And the question says, "What if I had an order against me denied, but in duress asked to have it kept on me? Yes, I know it's crazy, but it was stemming from a probate case and I was being strong-armed by my greedy sister and was in duress. Sounds to me like this, let's say it's a gentleman, wanted the restraining order against him so that he could maybe not have to deal with his sister, maybe. I don't know. What's your take on this?
I have no idea what the underlying order is that he's referring to. It's obviously in the probate case. So those are generally not domestic violence restraining orders. So I'm not really quite sure what kind of an order it would be. I would have to look at it. But just briefly, I would say that an order issued by the judge is an order issued by the judge, and they're expected to be followed. If something had been done that was inappropriate, I mean, usually you can't file a motion to set it aside if it was done in front of the judge. Because usually the judge is sitting up on the bench and looks at both sides and says, is this what you guys want to do? And they say yes. And that's usually the end of it. But again, without knowing what the order is or what he's even asking, and what the nature of the duress was, it's kind of hard to guess what we have to do here without getting a lot more information.
Yeah, and if this is related to property or person, or both.
Right, and it's in probate court, so
Yeah.
not something I have a lot of experience with, but some.
Yeah, sorry we can't give too much help on that there in your situation. Not entirely clear what's happening there. If we didn't get it right, go ahead and make another comment or join us on a live stream. All right, let's take a look at another one. This is a comment on our last live stream from last week. And it says, Hi, divorce court that says not needed to be present. Do I have to attend? I had 2 court hearings the same day. The court clerk said no need to change because there was a no-show necessary. Is this correct? Any idea what she's saying here?
This one kind of scares me because I'm not really quite sure what she's saying. And if I tell her she doesn't need to show up in court, that could certainly come back and bite her. I don't know. I mean, sometimes the judge will say to me or my client, there's no need to be personally present, and allows them to be present on Microsoft Teams out of San Diego. And that's still a very common practice. So maybe that's what the judge meant, which would still require an appearance just over the Microsoft Teams interface. So I don't know if that was it. God, I mean, I have a real hard time telling people not to show up for court without knowing exactly what was going on. It certainly wouldn't hurt to talk to the clerk about what's in the minute orders on these 2 things. And she says she has 2 court hearings the same day. I'm not sure if they're in the same department or if they're in different courthouses in different locations. If they're in the same department, I would just say show up for both of them. You're not going to get in trouble for showing up. And if they allow you to appear either telephonically or through Microsoft Teams, you can do that as well. I always tell people if they have the ability to show up in person. Sometimes the Microsoft Teams interface is not perfect, and it makes it easier for the court to have you present in court to be able to hear you and understand what you're trying to say. That being said, if you're located in Florida and the court case is located in San Diego, you probably don't have a choice. Or, even if you do, it may just be too expensive to fly out to San Diego to appear for one hearing. So I don't know. It kind of scares me to tell somebody not to show up for court.
Well, I wonder if the hearings were taken off calendar and the clerk says don't show up because you don't actually have a court hearing anymore because it was taken off calendar. Or perhaps like you could see it as a situation where let's say she's the respondent in a restraining order where someone had requested a restraining order against her, that she be restrained, and then the person doesn't show up at the hearing, the petitioner doesn't show up.
When I read this, it said divorce court says not needed to be present. I was assuming that was the judge, because I get the judge telling me all the time, saying I can appear telephonically or via Microsoft Teams. I think you might be right. It might have been the clerk that told her that. In which case, go back down and talk to the clerk and get some clarity. If it's off calendar, then certainly you don't need to attend. Now, the other thing that could happen is, the judge may set a case management conference to make sure that a judgment has been entered. And if the judgment gets entered, then you don't need to be present, because the matter gets taken off calendar, like you just suggested, in which case, you can find out before the hearing and confirm that it was in fact taken off calendar. If it's off calendar, you don't need to be present. But if it is still on calendar, I would try to be present in one way or another.
Yeah.
Ding.
Sorry about that. That is my phone. All right. Let's take a look here. Let's get another one. Okay, here we have our video, how to fill out the income and expense declaration in California Family Court, which is Form FL 150. And the comment says, hello, I am married and unemployed. Do I put in my husband's income under spousal support?
This one's easy. The answer is no. Assuming she's still or currently living with her new husband, she would actually put that in on page 3 under number 12. The following people are living with me. List the husband. He's related to me because he's my husband. And then you put that person's gross monthly income at that point. If you put it down under section 5, which is income, then that might be usable against you for purposes of determining support. And it's not supposed to be. If you just put it down on page 12, that informs the court that your household has this income coming in, and it helps to explain how you're paying your total monthly expenses.
So it needs to be in the form, but in the right spot on the form.
Yep. Section 12.
Okay, perfect. Thank you. All right, let's take a look at another one here. This is our video. Your ex violates the child custody or visitation order. File for contempt, Form FL 412. And this comment says, I've been searching for help and can't seem to find it anywhere, at least not decent advice. My ex and I went to court on Halloween of 2022. And since then, I've documented 3 times she's violated the court order. She's been late for an exchange well over 2 hours, and she failed to contact or answer my calls or texts. I had to get in touch with her mother, my daughter's grandmother, to come get my daughter after she sat at my job with me for 3 hours. And another occasion where she picked my daughter up from school for Christmas break, where I was supposed to get her. Of course, I didn't notify her that she slipped up and violated the order, but my child tells me that she stays with her grandparents 90% of the time when she's supposed to be in her mom's custody. But her mom is at her boyfriend's while her own mother looks after my child. Meanwhile, I'm paying this untreated, hateful person with $500 a month in child support, and we have 50-50 custody. It infuriates me because my daughter, who is 7, prefers to live with me, but I'm being played by a broken system and struggling to keep up with child support when I'm truly the only one parenting the child. I need help. Please, someone. My state is Georgia.
I don't know if the case is in Georgia or not. I'm assuming it is, in which case, I don't know. You'd have to take it up with a judge in Georgia. I'm not going to get into that because I've never been to a court in Georgia. Also, given the person's name, I'm not sure if this is some kind of joke? I don't know. The name of this commenter is suspect.
Yeah. So if this were in California and a real situation, which sounds like, I mean, this kind of stuff happens all the time, where you have 50-50 custody, but in this case, it sounds like it's the mom. The mom is not actually having the children in her care during her time, during her 50%. It's really grandma. And does that matter? Let's say this is a guy. Can he go back to the judge and say, hey, Your Honor, we have 50-50, but really the other parent's not taking advantage of her time. Can I, all the time that our daughter is with grandma, maternal grandmother, can I instead have her with me? And that would, of course, probably decrease the child support that he might be paying.
If it were California, I would say he probably needs to file a motion to modify custody and visitation because it appears that mom simply isn't around. But they were just in court 2 months ago. So it's kind of hard to believe that much has changed in 2 months. So maybe not, but there's something wrong here. And as far as whether or not that's going to change the order for child support, again, I have no idea what state this is. In California, timeshare absolutely changes the amount of support that somebody's paying. In other states, they don't do it that way. Like in Texas, whether you've got 0% visitation or 30% visitation, it doesn't change the amount you're paying. When you get closer to 50-50, then the judge has the ability to do some offset in those other states. And I'm not quite sure exactly how they do that. But in California, the court can do whatever they need to do. And, a lot of people have this idea in California that if you have 50-50 custody, that you're just not going to be paying any kind of child support. And that may or may not be true, depending on how the calculation comes out in the child support calculator. If dad makes $200,000 a year and mom's making $24,000 a year, even with 50-50 custody, he will be paying some support. Now he's going to be paying a whole lot less at 50-50 than he would if he only had, say, 5% visitation.
Mm-hmm. Okay. Excellent. Thank you. We have a comment here in the live stream. This is an excellent question. I love this question. She says, I have over 50. So she's preparing for trial and she has all these exhibits. I have over 50 exhibits for my trial hearing. I need to mark my exhibits per trial rules as respondent A, B, C, etc., using the letters of the alphabet rather than numbers. And the reason why this is because typically the petitioner or the plaintiff in a case usually marks their exhibits with numbers, and the respondent or defendant typically marks their exhibits with letters. And so she's right. How do I do this with only 27 letters in the alphabet when I have more than 27, when she has 50 exhibits? What does she mark them? Once she gets to Z, what does she do after that?
There's a few different ways to do this. You could just take out a Sharpie and write AA, BB, CC. It's probably the easiest.
That's what I do. You double up on the letter.
And you're not going to find pre-printed forms that say that. And so, just do them by hand. Hopefully you have good handwriting.
And then if you get to ZZ and you have more exhibits, then you go to AAA. That's what I do. Is that what you do?
I usually don't get to more than 50 exhibits, but certainly could.
Yeah.
Yeah, of course,
use a marker.
The judge can always order something else. Like I have a case right now where petitioner gets, all the exhibits are going to be numbered, and the petitioner gets 1 through 200, and the respondent gets 201 through 400. And there was no indication of what we should do if we have more than 200 exhibits.
That's a really great comment. What you can do is call the court clerk in that department where your hearing is going to be, or go to the courtroom and ask the clerk what that judge likes to do if the clerk knows. And the clerk might have stickers. You can say, do you have any exhibit stickers that you can give me? I have 50 exhibits. And they may have stickers for you to put on pieces of paper to mark exhibits. And she might, or he might tell you, here's what the judge wants you to do, A1 or whatever. So that's a great question. She says, I need to amend my exhibit list and exchange it at least 20 days before trial. Does my amended exhibit list need to be served with proof of service filed? Good question.
Yeah. Yes.
And why is that the case?
But you always do. Anything that you give to the court gets served on both sides. And so you always serve it on the other side. And it's always a good idea to have a proof of service. If the other side is represented by an attorney, they're probably not going to make a big deal about not receiving documents, but you never know. And so always file your proof of service in case something gets lost or they claim they didn't get it. I never had problems with opposing counsel not receiving documents at some point. Usually what happens before a hearing, if they haven't received the documents, you'll get a phone call and they say, hey, I never got anything here. And you go, oh, well, I mailed it or I emailed it on this date. And then they either find it or you make arrangements to get them another copy quickly. But it's a good idea to get a proof of service saying that you sent it over. And the next question, can service be by email? Usually, yes. If you've ever exchanged documents with the other side by email, then the answer is yes. If not, a phone call to the other side, and usually they're going to say yes because it makes it easier for both sides. But when it comes to exhibits, maybe not. It might be easier to print everything out on paper and walk them over. If you have 500 pages of exhibits, email might not be easier for you. It might be more difficult. It just depends on your circumstances. Do I need to file my exhibits with my amended exhibits list? Usually the court will give you some indication of when you deliver the exhibits to the courtroom and how to do that. If they don't, Tate's suggestion of talking to the court clerk is a good idea. And they will tell you whether to bring it to the business office or whether to bring it directly to the department. It's going to depend. Even in San Diego, Department 5 in El Cajon might do something different than Department 6 on any given day of the week. So it doesn't hurt to ask. Those questions will not be, ignored or thought to be funny or anything like that. You're going to call the clerk because you're trying to make the clerk's life and your life easier by asking how to do it the way they want it done. And they always are helpful to say, this is the way I'd like to do it. Like I've got a case right now down in San Diego in front of Judge Calum-Carrion, and she has a different way of doing it. She doesn't want binders. She doesn't want the exhibits just sitting loose in each one that has a tag on it like Tate was talking about. She wanted each one separately in a file folder with just the number on the file folder so she could just pull out Exhibit 43 when looking at Exhibit 43. And we've now done the first day of trial with that, and it seems to work. So whatever the court wants to do, you just do it their way. It's easier to do it the way they want it because it makes trial go faster. Instead of, fumbling around looking for exhibits, everybody's got them exactly where they want them and they understand the organization of how those exhibits are put together, and it just makes it easy to go through it. Opposing counsel in the case I was just talking about actually put something called a bait stamp number on the bottom of the form on every single page. And so we'll just say it's 500 pages long. So even though exhibit 1 might be pages 1 through 10, and exhibit 2 would then be 20 through 25 or whatever the number of pages is. And that way she can always sit there and say, let's go to page 433, which is part of exhibit 43, makes it real easy and quick for the court to find that exhibit. And people aren't sitting there going, hey, what page are we on? What are we looking at? You avoid wasting all that time, because when you're in trial, especially when you're talking about 50 exhibits, that's going to take a lot of time to go through those exhibits. And so whatever you can do to make it easier to find those exhibits quickly and get to them quickly and have the court get to them quickly would be very appreciated by the court.
Yeah, I loved your comments about how these are not silly questions to be asking the clerk. Don't be afraid to ask questions. You're not going to look foolish. They will appreciate that you're asking because you ask because you care, because you want to do it the right way. They appreciate that. Most of them will. And some judges, Chris said that judges have different opinions on different preferences on what they want. Some judges will want electronic or digital copies and physical copies. So if you have everything scanned, that might be a good idea. Or if you don't, it might be a good idea to do that, but talk to the clerk.
And in federal court, we actually have to upload each exhibit into the appropriate exhibit number. So the judge can click exhibit 1 on the screen and it brings it right up. But, we're talking about state court right now. And so it doesn't hurt to talk to the clerk and ask them how they want it done. And they may say, you probably ought to look at local rule such and such that spells it out. And sometimes an individual department will have their own published rules on how they want to deal with this stuff.
That's a great point too. Look at the court website and see if you can find information on exhibits. Some, I don't know about Riverside. She's in Riverside. Some courts, they'll have a website or web page for each courtroom, and where the judge says, "Here's what I want you to do." Some judges, they want one PDF, but you have to bookmark each separate exhibit in that PDF. So anyway, good discussion. Anything else on this?
No.
Okay, let's look at another comment on another video. All right, this is our video. Agree to end your marriage quickly. Jointly request summary divorce in California Family Court using Form FL 800. And the comment says, can I do a summary dissolution if my spouse is willing to cooperate, but we were married in another country?
As long as both parties are residents of the state of California and have been for 6 months, you can get a divorce here in California. That's not to say it's going to be enforceable in another country. I don't have a whole lot of experience. I can't tell you whether or not Hungary would be able to would somehow object to an order of dissolution of marriage from California. I doubt that would be a problem. Places like New Zealand and Australia, I'm sure there's some kind of a process to get that judgment recognized in those places. Places like China, I have no idea. But assuming both parties are here and continue to remain here, then you get divorced here. You get judgment saying, here's what we're going to do with the property. Here's what we're going to do with support. And, as far as anybody cares, because everybody's here, the California court has jurisdiction and all of that is good. You get into some crazy situations where what happens if somebody who has all the money moves back to Greece? Are you going to be able to enforce the judgment there? I don't know. You'd have to talk to an attorney from Greece to see what the process is for doing that. And you would also have to see whether or not, there are a series of treaties that would cover the various countries to figure out whether or not judgments are enforceable. So that's what you would have to do. But, being in San Diego, the one that, you would think I'd see it more often, but maybe in 19 years, I've seen 4 or 5 cases where we had to deal with some kind of an issue down in Mexico. And there are certainly ways to do that between the California courts and the Mexican courts. But it doesn't happen that often. But that could certainly be a problem for halfway around the world. Maybe Estonia, I don't know. Is there some way to enforce judgments out there from California? I have no idea.
And if there is no judgment, if there was no divorce started there, if they're just starting a divorce here for the first time. Is that a problem?
I don't know. It's going to be very specific. You got to do some research on it. So let's say, husband is filing in Mexico and wife is filing in California. There is a process by which the two judges can talk to figure out who's going to have jurisdiction on the case. Ask the same question about, a dissolution of marriage being filed in California and the other one being filed in Russia. I have no idea. And given the current state of the world, I don't know that anybody can answer that.
Yeah, and does the judge have jurisdiction? Let's say there's property, real estate or heirlooms or something like that in another country. Who knows? There are lawyers who specialize in international divorces. If this is the situation, it sounds like maybe it isn't, but who knows? Maybe it is. And like there's a lawyer here in San Diego who specializes in international divorces. I only know of one. In Florida, there are probably divorces like that or lawyers like that as well. Yeah, I would say talk to them. Okay, let's look at anything else on that issue.
No, good.
Okay, let's look at one more comment from a video, and that will be our last comment from a video. Then we can get to some of these questions here on the live stream. I'm not entirely sure this is a question, though, honestly.
Doesn't look like it.
Yeah, this is a clip from our last live stream regarding contempt. When should I bring a contempt action against my ex in California family court? And he says, opposing attorney ordered to file substitution after a phone appearance. Opposing counsel failed to file. I call it the "you can't serve me" game.
I have this come up from time to time, and it's irritating. And so what you do when somebody appears that's never appeared in the case is you get their name. And when they make their appearance in front of the court, they say, "Hi, my name is attorney so-and-so." You write it down. And you can then go out to calbar.org and you get their name, address, and phone number, and now you have it. And at that point, you can serve documents on that lawyer. You can also serve documents directly on the other party. Since they've made an appearance in the case, usually that service can be done by mail. If they've put their email on something, you can do service by email. Given that this is asked under a video that talks about contempt, I'm not sure whether this person is the person who's filing the request for order or the order to show cause regarding contempt, or whether it's the person that's responding to it. If this person is responding to it, then absolutely you can serve it by mail, email, whatever. You can call the person, get their email address, and for the most part, they're not going to give you a hard time. I mean, counsel doesn't want to create problems about how to serve them with documents. But if they do, you got to remember that a contempt action is not necessarily the same thing as a regular family law case, and criminal rules apply. And so you have to get them served in some manner, shape, or form. And, the rules for doing that are usually pretty straightforward. And like in criminal court, and sometimes this is the problem, because this may be a contempt case where it's the attorney making the appearance is not a family law lawyer, but perhaps somebody that's got extensive experience in criminal law. And so in criminal law, almost everything is done with oral motions. And in family court, almost nothing is done with oral motions. And so, you get their name, give a phone call to them and say, how do you want these documents? Or you just simply have somebody show up at their office with whatever, because you're required to get them the documents in advance of the hearing. And so that's what you have to do. And I don't expect there to be problems with the attorney or the people who work at the attorney's office. If you didn't get their name at the hearing, then you might have to go make a trip to the courthouse to look at the minute order, because they will have written down the name of the attorney who appeared. And that's how you can get this thing done. As far as whether or not they file the substitution of attorney, you can bring that up with the judge when you next appear in court. And it's not going to be a big issue one way or the other, but this service thing is kind of a pain in the neck.
What if the lawyer's subbing out? Like the lawyer saying, I'm no longer representing the opposing party. Well,
but their name is still on the pleadings then. So that's kind of a problem for them. And so if they won't give, so for example, they won't give you the name, address, and phone number of the client because they're subbing out. Well, then and you don't really know how to serve this person with paperwork, then that's going to be a problem. And, usually that problem is going to fall squarely on the shoulders of the attorney that's not following the court order. The other thing that, we don't really think about in family court, but once this is a criminal action, you need permission from the judge to sub out of a case. And they do that specifically to avoid this problem. So I was just assuming that the attorney was subbing into the case, which is common. They get hired at the last minute. They show up for the very first appearance at an arraignment on contempt, and there you are. And then the judge sets hearing dates and trial dates and all that other stuff to get this matter resolved. So I think you're right, Tate. It could be subbing in or subbing out, but I was assuming it's subbing in because that's where I normally have the problem.
Can you just serve the party, the opposing party, rather if it's, let's say it's subbing in, or whether it's subbing out too? Can you just serve the party and say, well, forget the lawyer, I'm just going to serve the party. The lawyer, I don't have the lawyer's contact information. They're ignoring me. I'm just going to serve the party, assuming.
I would serve both if you can. It depends on how big of a pain it is. Again, if you've got the attorney's name, call their office, and if they want to be difficult about it, you can bring that up at the next hearing and say, I don't know what to do, Your Honor, but, they said they were subbing in, and that's why I served the papers on them, and now it appears they've never subbed in. And now this attorney is going to have a real problem with the judge because they made an attorney in front of that judge, and that judge ordered him to file the substitution of attorney and didn't. And so that could be a real problem for that attorney if they don't want to behave in a responsible manner.
Yeah.
I'm assuming that this is just an oversight. The attorney's been busy. They just haven't gotten to it or whatever. But usually you can clear that up with a phone call. Hey, are you still in this case? Yeah. Okay. I need your address for service of documents or, whatever. And, if the attorney's no longer going to be on the case, they're going to say, oh my God, the other party said they were going to pay me and they never did. And that's why I don't have this because I asked her to come down and sign the substitution and they never did. Okay, well then that explains why it didn't happen. And so then the next question is, okay, so should I serve the documents on you or what do you want me to do? And, at that point, the attorney's going to have to make a call about whether they can receive the documents. Again, I don't really want to be that attorney in a situation saying I'm not going to receive documents after I made an appearance in front of a live judge saying I'm on this case. That just sounds very problematic.
Because usually it's, maybe, I don't know, maybe not usually, but you would think, hopefully it's not the lawyer playing hide the ball. Hopefully I think it would be more likely to be the opposing party who's saying, well, if the sub isn't filed, then they can't serve me, And usually if the lawyer is subbing out, usually they're anxious to get it filed, to wipe their hands clean of the case and move on.
Usually. And again, this problem that I'm talking, I said I've had it happen to me. It doesn't happen often. So, it's only once in a while. And, again, call the attorney on the other side, find out what's going on. And, if they continue to refuse to respond to your phone calls, your emails, whatever else, you can tell all that to the judge when you get there and say, I did my best to find out what's going on. I located their name on the calbar.org record. And so that's where I sent the documents. And so now, you relied on the fact that they made the appearance and you relied upon the fact that the judge made an order that they expected people to follow.
So if the judge subs someone in or out, is that a court order that takes effect immediately? In other words, you don't have to wait for the actual document to be filed. It's if the lawyer is subbing in, they're already subbed in. The judge says, "Okay, you're the new lawyer." Right then and there, it's in effect.
Yeah, I wouldn't call it an order. I would say that attorney made an actual appearance and represented to the court that they're representing this party. And so, yeah, it takes effect right then and there. Now, if they're going to get off the case, that's kind of a problem for them. And so then they need to act very reasonably. I mean, if it was me and, I had a client that says, I want to hire you, you show up for the hearing. And then the next day the client says, no, I don't want to hire you. And then the party calls me and says, hey, how come you didn't file the substitution of attorney? Well, then I'm going to be very upfront with them saying, well, she fired me the very next day. And, here's her information on where you can serve her paperwork, or I keep saying her, but it could be him or her. And so here's how you get that paperwork to it. Because I don't want to be in a position where I'm being disrespectful to the court. If the court was expecting me to file a substitution of attorney, I'm going to do it. And at that point, I have an obligation to try and figure something out with service of documents, because otherwise those documents are going to come to me. And then I have the obligation of somehow figuring out how to get them to a client who's not a client. And it's very messy, and you just don't want to go there.
Yeah. Okay. Good discussion. Thank you. Anything else on that?
Nope.
Okay. Let's look at this comment from the live stream. It says, does the clerk in El Cajon help you? I asked because they seem to not offer any assistance.
Well, they do have a family law facilitator there. So the facilitator's office is very helpful on anything that comes even tangentially close to the issue of child support, getting judgments entered, and that sort of thing. There are some things regarding property disputes that they won't get into, but they'll tell you. So sometimes the clerk will help you, depends on what it is. They're not supposed to give you legal advice. They're not supposed to tell you what kind of forms to fill out. But if you show up and a form is not properly filled out and it's missing party names and case numbers, they'll usually tell you, you need to make these corrections before you try and file it, because I don't know what file to put it in. But as far as telling you what to put on a form, no, the clerk isn't going to do that. But the facilitator will, depending on what the issues are.
Yeah, and I'm not sure which clerk this is, if this is a clerk in a courtroom or if it's in the clerk's office. That you'll probably get a different experience, especially if it's like you're in the courtroom and the judge is sitting on the bench versus if the judge is not sitting on the bench.
They don't have time. They're not going to interrupt the judge and take up the judge's time with issues where you're saying, hey, what forms do I fill out? And they really can't tell you to do that anyways. Again, they're not allowed to give legal advice, but sometimes they're allowed to tell you what forms to fill out. But at least the facilitator in El Cajon, you got to get there early in the morning to be on their list. But once they look at it, they will help you and at least get you going in the right direction.
Okay, thanks. Let's see. These comments say, this is back to our first commenter. My ex is on his second attorney. I received several confidential settlement offers from his first attorney in 2021 and in 2022. None from his second attorney. Since his first attorney is no longer representing my ex, can I submit the confidential settlement offers as evidence? The document says...
Evidence of what? That's my question.
Yeah, the document says confidential settlement communications per evidence code 1152 and 1154 shall not be used unless as it relates to attorney's fees and costs. Yeah, is that what you would want it for? What's the relevance of the evidence? Maybe there's an admission made or something like that in the settlement.
So like if we're talking about a custody and visitation case and the attorney sends over a letter saying, let's resolve this case by doing this.
Uh-huh.
And then for whatever reason, the parties don't agree to it. At that point, that settlement offer would not be admissible as evidence to say that's what the court should do because they offered it at one point. Offers like that are not admissible. Now, if at one point, somebody sent over a settlement offer and then somebody unreasonably withdrew that settlement offer, which caused you to incur $10,000 in extra attorney's fees, that kind of conduct is not appreciated by the court. And you could, if you had an attorney, your attorney could file a motion for sanctions saying they withdrew that settlement offer. And that could absolutely be used against him in a motion for attorney's fees, depending on, the circumstances in your case. But the next comment says he offered zero child support in exchange for sole legal and sole physical custody. Yeah, that's kind of an obnoxious offer. But I'm not, again, quite sure why you're trying to put it out there, except maybe make the attorney or the party look bad. That may not get you very far. Instead focus on the underlying issues of the case. If what you're focusing on is legal and physical custody, then explain to the court why you want legal and physical custody and why it's appropriate in your case.
I think this is a case of like very high conflict, and sometimes very often a judge will blame the parents for the high conflict because of either actual or potential consequences, emotional consequences that it has on a child, and might sort of punish a parent for being unreasonable and making this divorce harder than it has to. Maybe she's trying to say, look, it's not me. I'm not the problem here. They're being unreasonable. And maybe that's what she's getting at here.
Right. So if the issue of attorney's fees is before the court based upon sanctions, then probably that letter would come into evidence to show who's being reasonable or who's not being reasonable. But if it's not at issue before the court, and the only thing at issue before the court is legal and physical custody, then that letter may not come in. Yeah, you can always add it as an exhibit, and the judge may say, I'm not going to look at it. Okay.
Right. That's right. I agree with that. That's what I was going to say. When you do your exhibit list, I think she's already had her settlement conference. It's passed, but normally you're gonna say, here's the exhibit, and here's the evidence code that makes it admissible, and then the other side can file their in limine motions, and they can file a motion saying, here's why it's not admissible, and then the judge can rule on this. Hopefully the judge can rule on this stuff before the trial starts. So it's all the legality, the admissibility of this document will be decided upon and argued before the trial starts.
So then she has a comment that says, divorce is already final. I'm trying to show that he's being unreasonable. So is it unreasonable because you're asking for attorney's fees from him because he's been unreasonable? Then yes, the document comes in. If you're simply trying to show that he's being unreasonable in the question of custody and visitation, then maybe not. But it's hard to say. I'm not quite sure what she's getting at. I mean, it sounds like, well, I don't know. Maybe she'll comment again.
But put it in your brief. Explain why it is you want the judge to look at it, and the judge will make a decision. What do you think about that?
Sounds good.
Yeah. Okay. Well, that's all the videos that we have to look at, all the video comments. I don't see anything more coming in through the live stream. We'll wait maybe 3 more seconds and see if there's another one coming. Hopefully that was helpful, Christina and Andrew. And next up is trial. Yeah, you're on your way, it sounds like. So make sure you get all that exhibit list ready to go, and make sure you are able to identify the evidence code that makes each exhibit admissible. And yeah, and I'm excited for you, and I would say congratulations for the work that you're doing. A lot of people don't put in that effort, so good for you. Okay, we hope that you will be willing to like this video, that you will be willing to subscribe, and write any comments in the video so that more people can get the help that they need for their court case. Check out mycourtcoach.com. Any final words, Chris?
No, have a good evening, Tate.
All right. Thank you all. Take care.
Bye.
Bye-bye.